further hearing in the appeal for Airways plc against Williams and others.
Mr. Giles.
Please, your lordships and your ladyship. May we start with a little housekeeping? You said one or two tasks overnight, and I'm afraid we responded a little over-enthusiastically. You should have, first of all, jointly, a chronology which sets out the various measures, dates of the relevant agreements, the dates of the directives, bringing them into force, and so forth.
Thank you very much.
That is an agreed document. I've also handed up the outline nutshell from which I read yesterday, the nutshell of the BA case, simply as a one-page guide to what we say.
Sorry, more and bottle, you mean?
More, no, this should be this document. Yeah.
I've got appellant bullet points. Right.
Yeah, our bullets are shorter, not to say sharper, than no friends. If I just ask Mr.
What it look like?
Just asking Mr. Short if he could pass up something.
No, we haven't.
I think that's the only thing we haven't got.
Right, you can ask. Apologise for the volume of all this.
Right.
Also, you have from our side Section 85 of the Merchant Shipping Act, under which the shipping regulations, the non-fishing seafarers regulations were made. And the simple point here, really just picking up on Lady Hale's point yesterday, is that those regulations, as she spotted, were made both under the European Communities Act and under the Merchant Shipping Act.
This is a sort of in a general clip of legislative material.
Yes.
It's halfway through that, yes.
The material point is to note that it's a health and safety provision, which makes it all of a piece with the purpose of the European working time legislation. So that's the short point that comes from that. Also from our side, you have, though it may not be necessary to go very far into this, sections 64 and following of the Employment Rights Act 1996, taken from Butterworth's Encyclopedia, which deal with the right to remuneration on suspension on medical grounds, which was touched on yesterday. And a material point to note there is that under section 69, which is on the second page, the right to remuneration is a right to remuneration at a week's pay, which of course then falls to be calculated in accordance with sections 221 to 224. So there's an express statutory scheme in relation to suspension on medical grounds.
Because this is a consolidating act, isn't it, the 1996
It
Act?
is.
So an awful lot of what we're looking at in that Act dates back a bit, doesn't it?
It does. A lot of it comes from the 1978 Employment Protection Consolidation Act, which itself consolidated the 1975 Employment Protection Act.
And so all this stuff about weekly calculation
Yes.
goes back way before
It
96,
does.
doesn't it?
It used to be in Schedule 14 of the 1978 Act. And
You have the advantage of me, Mr. G.
many of us know it.
It goes back to 1963,
Well,
originally.
that's what I thought, which
Yes.
is
Goes
why
back-
clearly what happened when they had to do it, they picked up something that was already
Yes.
there and had been around for a long time.
Yes, I think it starts with the Contracts of Employment Acts in the 1960s and the Redundancy Payment Act, but certainly it was Schedule 14 to the 1978 Act. Obviously, bits have been added on as maternity rights have developed, but you see that there is a specific statutory scheme incorporated to deal with calculation. And similarly, in relation to maternity pay, we haven't burdened you with the full range of provisions in relation to this. What we have excerpted is the a section from the Statutory Maternity Pay General Regulations 1986, which set out in some gory detail how one calculates earnings for the purposes of statutory maternity pay.
That could have been better put, Mr. Jeans.
Yes. One sees in section 20, or regulation 20, a very precise definition of earnings, and in regulation 21, the way in which you compute normal weekly earnings. And in fact, there's a special, in regulation 21.3, there's a special 8-week reference period. And all we draw attention to is that that is a highly specific and complex set of regulations, as they need to be, for computing how maternity pay as such is computed. And we'll come in due course to our general submission that one needs a scheme in order to give effect to all the complexities of irregular payments. But that's a submission for later. The other document which comes from our side is the version applicable at the time of these proceedings of Article 5 of the European Union Treaty, which sets out the principle of subsidiarity. I referred to that in passing yesterday. I thought perhaps it was right that your Lordships and your Ladyship had the principle in front of you. It's really the second paragraph of Article 5. In areas which do not fall within its exclusive competence, the community shall take action in accordance with the principle of subsidiarity, only if and insofar as the objectives of the proposed action cannot be sufficiently achieved by the Member States and can therefore, by reason of scale or effects of the proposed action, be better achieved by the community. And the key word there is only. An action by the community shall not go beyond what is necessary to achieve the objectives of this treaty. So that's the famous principle which seeks to confer discretion or emphasise the importance of Member State discretion. And that is central to an approach, we say, to the working time legislation. I think my learned friend had one or two things she wanted to hand up, and it might be, or at least to identify as having been handed up, it might be convenient to allow her to introduce those at this moment.
Yes, well, what's been handed up on our side, the bullet points that my Lord Brown requested yesterday.
I'm very grateful.
Those have been produced. We then have a document called Information for Pregnant Pilots, which sets out the factual background, the way in which the calculation of pay whilst grounded is carried out. And the only paragraphs of this that I think you'll need to look at are on page 6, at paragraph 2C, which set out both pay whilst grounded and statutory maternity pay. This is a guide for pilots, and you'll see pay whilst grounded halfway down. They're paid maternity ground pay, which is individual average monthly remuneration over the period of 12 weeks prior to cessation of flying duties. That remuneration being basic pay, appointment pay where appropriate, bid line variables or day off working payment, and then to highlight flying pay and the taxable element of time away from base allowance. And then statutory maternity pay, just below that, is paid at 90% of your normal earnings during the qualifying period. And that is...
Does it tell you what your normal earnings are?
It doesn't explain what your normal earnings are. We have some pay slips, but we haven't sought to put those before you at this point. So I can say this only on instructions, and it's a matter I probably need to discuss with Mr. Jeans over lunch. normal earnings are, once you go on maternity pay, what you've been getting as maternity ground pay. It takes into account what your earnings were. And that makes sense.
A bit bizarre if it didn't really, wouldn't
Yes,
it?
it's the 8 weeks that, as it says, that precedes, the period of 8 weeks ending with the 15th week before the EWC.
And that is paid by the employer, but funded by the taxpayer ultimately, isn't it?
Exactly, my lord, yes. And then the other document, which is a contractual document, is the maternity adoption and paternity leave contractual policy, which we referred to by number yesterday, EG 403, which you see down in the bottom right-hand corner. And the only passages I would wish you to have a look at in that is, for the sake of completeness perhaps, page 4, annual leave, paragraph 4.3, which I simply invite you to read at a convenient moment. And then on page 8, employees entitled to statutory maternity pay, and just over halfway down you'll see SMP is 90% of normal weekly earnings. And that's there set out in the contractual policy. So, yes. And we say FPS and TAFB obviously included. The only other document that we've put before you, which I think Mr. Jeanes has briefly referred to, is the case of British Airways against Moore and Bottrell. Which I'm not going to address you on at this stage, but I simply flag up it's before you. It was a case concerning suspension on maternity grounds and the right to remuneration over that period. And the complaint was that only basic pay was being paid. It was held under that particular scheme that flying allowances should be included, that is, flying pay supplement and taxable element of time away from base allowance.
Thank you very much.
As your lordships will see, your ladyship will see the issue in Moore and Bottrell was whether certain employment was suitable alternative employment. It wasn't actually an issue about what was payable, but I think there's no great issue about it between us that there is a detailed agreement, as there needs to be, to regulate what sums people are paid when they are grounded. As regards maternity leave itself, that's say when somebody goes off to have the baby, that's all governed by these very complicated regulations which set out the 8-week reference period and define in great detail what's to be included and what's not to be included. The Employment Tribunal was taken to a little of this and expressly commented that they found it unhelpful. But your lordships may or may not agree with that observation. Lords and Lady, yesterday I was at the stage of my submissions of saying that the Aviation Directive, in common with the Working Time Directive, confers a discretion and is not prescriptive about the calculation of pay. And I was in particular developing this by reference to the authorities which stress that as a health and safety measure, there is no reason why it should be concerned with matters of calculation. As long as the payment is at a level which does not discourage the individual from taking their leave, then the objective of the directive is satisfied and there's no basis for complaint. And I want to take you first to two English authorities that deal directly with the point, English Court of Appeal authorities, and then address the two European cases which really form the whole foundation of Learned Friend's submission. I'll take you first to BAMSI, which is in Authorities Volume 2, at tab 22, it's at the front of the volume. This was a case where the applicant, claimant as we now call them, was employed with a working week of 39 hours, with overtime of up to 9 hours if required. But he in fact worked nearly 60 hours, and in the material period averaged 58. He said that he ought to get his holiday pay by reference to the time he had actually worked, rather than his contractual minimum of 39 hours. The Employment Tribunal applied sections 221 and following, the result of which was no inclusion for overtime was made in the holiday pay. And on appeal, it was argued that the English regulations were either inconsistent with or should be construed in the light of Article 7 of the Working Time Directive. As it was said, this conferred a right to a higher level of pay than sections 221 to 224 provided. And we'll see from the holding, held dismissing the appeal, that the purpose of the Working Time Directive was to encourage a climate of protection for the working environment and the health of workers. And while it laid down in Article 7 the principle of entitlement to 4 weeks annual leave, it did not require member states to ensure that the workers received more pay during their period of annual leave than they were contractually entitled to earn. That Regulation 16 of the Working Time Regulations 1998 incorporated, for the purposes of determining a week's pay, not only sections 221 to 224, but also the interpretation of normal working hours, and on an analysis of sections 221 to 224 and 234, where overtime was worked, only that which the contract of employment required the employer to provide and the employee to do counted as normal working hours for the purpose of calculating a week's pay, and accordingly the applicant's leave pay was to be calculated by reference to his contractual hours only for the purposes of Regulation 6.1. If one goes to the key part of the judgment at paragraph 34 and following on page 1098, Lord Justice Auld giving the judgment as a Court of Appeal. In my view, there's nothing in the directive to suggest that the construction of the term a week's pay in the 1998 regulations, so as to give it the same meaning for their purposes where overtime involved as that in sections 221 to 224, would offend its main or any of its purposes, so as to require, as Mr. Hendy suggested, a purposive construction to the contrary. The clear purpose of the directive, and I've said more than once, is to encourage a climate of protection for the working environment and health of workers. So much is clear from its recitals, some of which I've mentioned. And Article 7, in its provision for member states to ensure that workers are entitled to at least 4 weeks annual leave, clearly has their health in mind. But I do not see on what basis it can be said that it requires member states in its implementation to ensure that workers receive more pay during their period of annual leave than that which they were contractual to earn and did earn while at work. First, Article 7 expressly qualifies its declaration of workers' entitlement to at least 4 weeks paid annual leave to the qualification that such paid leave is to be in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation or practice. Such conditions necessarily involve, we underline this sentence, such conditions necessarily involve definition of the basis on which payment is calculated for such period of leave. Secondly, and consistently with that qualification, Article 7 is silent as to the level of payment for annual leave to which a worker is entitled. It does not, for example, provide that payment during such leave should equate with a normal week's pay when the worker was at work, or that it should be calculated by reference to working time, as calculated in Article 2.1. Thus, the European Union has laid down the principle of an entitlement to 4 weeks paid annual leave, but has left the conditions of entitlement for implementation by member states. In leaving member states that margin of appreciation, it's not for domestic courts to venture a means of calculation that would be contrary to the clear terms of such implementation, effected within the margin of discretion allowed by the directive. And then he goes on to consider the Gibson case, where Article 7 was held not to be directly effective. And then at paragraph 39, as Mr. Linden observed, common sense also points to the conclusion that the directive had to leave it to member states to decide how to calculate the amount of remuneration payable in respect of the absolute entitlement to 4 weeks paid leave. The pay systems of different employers across the European Union differ. A workable common definition would therefore be difficult to achieve. We underline that. In the United Kingdom alone, sections 221 to 224 illustrate the range of issues that would need resolution. For example, where pay varies according to the amount of work done, or time worked, or where there are no normal working hours, this case. Questions as to what benefits are to be included in pay for this purpose, and whether pay should be calculated at basic or at overtime rates. It follows, in my view, that unless the conditions of entitlement laid down by Regulation 16, as I've construed it, are such that they can be said to negate or frustrate the very purpose of the directive, which of course is the health and safety purpose he has outlined, the court must look at the regulation unassisted in this respect by the directive. And we say that that is the appropriate test. Does the English regulation, which in this case, of course, is the Regulation 4 of the CATWR.
Dispensed with the need for a precise method of calculation.
In my submission, not, and I want to develop in due course the fundamental difficulties of proceeding without having any form of scheme. We say it's simply unworkable. But what we're just concerned to underline for the moment is the basic test. Because this is a health and safety provision, because member states are intended to have discretion, the provision is only to be struck down or affected if it negates or frustrates the purpose of the directive. And it said in this case, not giving you what you usually receive, in this case substantial overtime, doesn't negate or frustrate the purpose of the directive. And similar reasoning appears in the Court of Appeal in the Marshall's Clay case, which I'd now like to turn. That is in the same volume.
How did they get round the argument that if the purpose of the directive is actually to ensure that people take the leave to which they're entitled, and you've got such a workaholic that he's working 60 hours a week, and if he takes that leave, he's going to be very much worse off than he normally is. How does that encourage him to take the leave?
Well, unless it can be said that he needs to earn more than his basic pay, it doesn't discourage him. The difficulty, obviously, is that once you start including irregular payments, you have to have some means of computing. Section 221 to 224 provides such a means in circumstances where those regulations apply. But where, as in the aviation regulations, you do not have such a scheme, it is simply impossible with irregular payments to say how much should be allowed, what period of reference should be taken, whether there should be an average approach or a mean approach. And one comes back to the basic question, is the worker going to be discouraged from taking his leave if he doesn't get this addition to his basic pay? And we say that the plain answer is no.
I mean, here, as I understand it, there's compulsory leave anyway. I mean, even if you didn't pay him at all, he's got to go on leave. So how does that play?
Well, it's true that the leave is compulsory, but it's also
just
true.
Try strictly health and safety and all that. I mean, you could say, well, we'll give him a £5 a week.
Well, no, we accept that if pay is in principle, at a derisory level, you could properly say, as a matter of ordinary English language, this individual isn't being given paid leave. But when they're getting their full basic pay, Yeah,
but that's different from the discouragement point.
Well, it is.
Entirely.
I accept that this case is special in this one respect, that the minimum leave and indeed certain additional days are all compulsory. But so one has to test it in an abstract way. But testing it in an abstract way, if it weren't compulsory, payment at this level would never discourage leave. No one would suggest that they would be discouraged from taking their leave simply because they didn't get.
So this is a hypothetical approach, notwithstanding the fact that the truth is that the leave is compulsory.
Well, it has to be hypothetical in this case because the leave is compulsory. But in my submission, the test still works. Well, what one is really asking in our submission is this level of pay so derisory as in principle would discourage an individual from taking their leave? And in my submission, that can't possibly be said. We're dealing with something which is a very substantial sum of money and which is on any view the basic or main income. And indeed it's the total sum which will be received in many weeks, because if you're not doing your flying, if you're doing your simulator training, or you're doing your resting, if you're doing other forms of training, you will not earn these sums. And one consequence of a learned friend's argument, which I'll come to in due course, is that if she's right, individuals can get more on holiday than they could earn whilst at work. If an individual's already done their 900 flying hours, for example, the year, then they simply could not have been required to fly in the following week. And if she's right, then they get a windfall. And as Lord Justice Auld said in the case from which I've just read, the Bamsey case, it's not intended that legislation of this kind should provide a windfall.
I mean, everybody else may find maternity, pregnancy unhelpful, but I mean, the points you've just made would apply equally in respect of these pregnancy payments.
Well,
you could earn more, you know, if you have your pregnancy at the suitable time, etc., etc., etc. And what's the policy which says, well, if you're pregnant, and all the rest of it, you know, you get all these bits and pieces on top of basic, but not if you're on holiday. Why?
Well, in fact,
Because pregnancy is not a holiday.
Yes. But if I could respectfully adopt that. But can I also make the point?
I'm not sure.
May I also make
But I'm not sure that it actually answers them.
No, well, can I also make this point, that, of course, you do actually get a reduction. You get only 90% when you're on maternity pay, and that's the effect of the regulations. So what they may give with one hand, they take away with the other.
At that point, but not for the initial, whatever it is, pre-confinement.
Yes. I mean, the reality is that there are separate policies at play, and indeed an entirely separate European regime, which indeed deems unfavourable treatment of any kind related to pregnancy to be unlawful discrimination. There are certain exceptions.
Including the 90% then?
Well, that has survived European challenge, but simply to explain why one has, as it were, a different set of rules, a different set of directives, and a different set of statutory provisions. I'm afraid pregnancy is and has always been treated as different. One's therefore not concerned with the same considerations. But the irony is, in fact, individuals are, because there isn't the 90% reduction, individuals are often better off on holiday than they would be when pregnant. And that has been unsuccessfully challenged in litigation.
Is there any European regime which deals with pregnancy?
Yes. There's pregnant workers directive.
And what does it say? What's the phraseology as regards pay?
I'll perhaps come back to you with the provisions in front of me, but in broad terms, there is a general prohibition on less favourable treatment of pregnant workers, but a permission of a maternity pay scheme which has to meet certain minimum criteria. That's the broad structure of it. But Mr.
I mean,
Short,
that might be interesting.
yeah. Perhaps I can come back to that when I've got the provisions just more literally at my fingertips. But I was submitting from Bamsey. This is the relevant provisions, even in the working time directive, which of course doesn't contain the same express discretions which are in the aviation directive. doesn't contain the same recitals which I read to you yesterday. But even in the Working Time Directive, there is said to be the broadest discretion for member states as to how to fix pay, and the real test is whether the level of pay is destructive of the right, whether it is so derisory as to be inconsistent with observance of the right.
This case, it seems to me, Bamsey, may be said to deal with a slightly different situation from our present one, because this was a situation where the first ground mentioned in paragraph 35 was that they weren't contractually entitled to earn these overtime payments. Well, in the present case, the pilots are contractually obliged to fly, and that's their job. So it may be regarded more easily as part of the normal week's pay than it was possible to regard the overtime in Bamsey as part of the normal week's pay.
Well, with respect, of course, I accept the facts are not on all fours, but pilots don't have a right to fly. No doubt if they were prevented from flying indefinitely, that might be a breach of an implied term in their contracts of employment. But they certainly don't have a right to fly in any given week, any more than the individual had a right to overtime in any given week. The fact that they're doing it in a given week is the product of the exercise of employer discretion.
It is in a sense, but it's there's a difference between someone who volunteers for overtime, which is presumably the case in Bamsey, and someone who can be required contractually to do overtime, or to fly, which is really part of his essential job or her essential job.
I mean, the position in relation to overtime is that even if you're required to do it, it doesn't count under sections 221 to 224 unless it's guaranteed. This is the effect of a very old case called Tarmac, Roadstone and Peacock, which is in the bundle and which is effectively applied in Marshall.
Can I just name that?
Yes, it's Tarmac, Roadstone, and it should be at the back of bundle 2. Yes, it's at tab 34, the old decision of the Court of Appeal, which has, as they say, been applied times without number.
And has not been referred to Europe.
No, this is a decision of Lord Denning and Lord Justice Stamp and James. You see from the head note, held allowing the appeal on the proper construction of, and there it is, a 1963 piece of legislation. The employees could not have their overtime counted in for the purposes of redundancy payments, that's week's pay formula, unless a fixed amount of overtime had been obligatory on both sides. And that's the principle which applies there.
And that's the forerunner, is it, of regulations 221 to 224?
Yes.
So it's a decision on the true construction in the
Yes.
sense of those provisions, essentially.
Mr. Schultz just helpfully passed me the Pregnant Workers Directive, and Article 11 of which, and we can obviously have this delivered to you as a yet further floating piece of paper in due course, in order to guarantee workers within the meaning of Article 2 the exercise of their health and safety protection rights as recognised in this article, shall be provided that in all cases referred to in Articles 5, 6 and 7, that deals with a range of cases where employees may be exposed to risk, the employment rights relating to the employment contract, including the maintenance of a payment to and or entitlement to an adequate allowance for workers within the meaning of Article 2 must be ensured, and that is then reiterated. There has to be the maintenance of a payment or an entitlement to an adequate allowance. But that is just the beginning of the story, and I won't take up your Lordship's time by taking you through the fine detail of the provisions. But
So the language is not the same as the language we're construing.
No, it is not. The background is different.
Sorry, we don't have that yet.
You don't have that at the moment. We can make copies if that would be of assistance. Having shown you Bamsey, can I then take you to a case decided only a month after it, the Marshall's Calais case, excuse me, paragraph tab 29, bundle 2, authorities bundle 2. Now this is the case which generated the reference to the European Court in Robinson Steele.
No,
This is
where was the... I've lost that one. Where's
that's
that?
tab 29 in Authorities Volume 2.
No, I know. Where's the one we looked at yesterday? Yeah.
Robinson Steele is tab 42 in Volume 3. But I'd
Yeah,
like
that's right. Because I noticed it was one of the three.
Yes. What I really want to draw attention to here, you'll recall what this case was about, the rather extraordinary practice, very widespread practice of rolled up holiday pay, where the employer would deem part of the employee's ordinary pay when working to include an element for holiday. So the real argument in the case was whether employees were being paid at all for holiday, and whether a provision in a contract saying, look, part of what you're getting covers your holiday, protected an employer from liability for holiday pay under the working time provisions. If I could read from paragraph 37 in the judgment of the Court of Appeal delivered by Lord Justice Laws. He refers to the Court of Justice in Bectu. The Court of Justice in Bectu, as I read the judgment, did not disagree with the Advocate General's reasoning. They drew an important distinction, which to my mind sounds in the present case. Excuse me. It is between the prescription of conditions under which the right to paid annual leave is to be enjoyed and the erection of obstacles which actually bar the right's enjoyment. The former is permitted to the Member States, the latter, plainly enough, is not. I've expressed the distinction thus in my own words, which I intend as a fair reflection of the Court's judgment, which he then sets out. If I could turn then over to paragraph 38. He notices paragraph 61 of the judgment in Bectu at the top of the page. Furthermore, the directive does not prevent the Member States from organising the way in which the right to paid annual leave may be exercised by regulating, for example, the manner in which workers may take annual leave to which they're entitled during the early weeks of their employment. Then goes on to say Bectu was dealing with a provision of domestic law which excluded the right to paid annual leave altogether for certain classes of workers. Those were people you'll remember on short-term contracts, in fact, because you didn't get anything for your first 13 weeks. And with respect, it is little surprise that the Court of Justice condemned the measure as unlawful. But given my rejection at paragraphs 24 to 26 above of Mr. Hogarth's submission that the contractual arrangements do not allow for leave at all, we are not on these appeals faced with anything approaching such a state of affairs. Nor was it suggested in Munro, which is another rolled-up holiday pay case, that a contract for rolled-up holiday pay constituted an exclusion of the very existence of the right to paid annual leave. The premise of the Munro decision, then, and of the argument in these appeals also, must be that even though it does not actually exclude enjoyment of the right, a contractual measure may place such obstacles in the way of its enjoyment as to be tantamount to its exclusion. I would certainly accept that there could be provisions in a contract of employment which so gravely obstructed the enjoyment of the right to paid leave that a court would be bound to hold that the right was denied surely as if it had been abrogated in terms. That is merely the consequence of the court's elementary duty to look at the practical effect of any measure which is said to violate the right. I would, however, incline to go further. I conceive that contractual provisions might be entered into which were not so obstructive that the court would distinctly hold that they denied any right in the absolute sense, but which nevertheless made its enjoyment sufficiently difficult or problematic that they would fall to be treated as repugnant to Article 7. There is surely an implicit but critical distinction between the creation of a framework or the imposition of conditions under which the right may reasonably be enjoyed and the establishment of barriers or obstructions which prevent or at least substantially inhibit its reasonable enjoyment. The former are entirely legitimate. Appropriate contractual frameworks and conditions may vary from member state to member state. Their legitimacy is underpinned, at least, by the spirit of the principle of subsidiarity. More concretely, it's in my judgment made clear by paragraphs 53 and 55 of the judgment in Bectu, which I've set out. It's also, I think, confirmed by materials such as the following, and then he sets out the definition of directive and so forth. And then paragraph 41, which side of the line any given set of facts falls may well be a matter of degree. Reasonable conditions and unreasonable or unacceptable obstructions are neither of them sharp-edged or precise ideas. What is the position in relation to rolled-up holiday pay? And then he gives his views in relation to that. Now, of course, we're not concerned with the Court of Appeal's conclusions on the facts in relation to rolled-up holiday pay, but in my submission, the distinction set out by Lord Justice Laws, which echoes the distinction set out by Lord Justice Auld in Banzi between obstructive conditions and permissible frameworks, is an important one. It's only if you can say that the national legislation is obstructive or destructive of the right that you can say that the discretion has been infringed, the ambit of discretion has been infringed. And to be our submission in this case, that no one could say that the right to paid holiday would be destroyed by the payment of basic pay. That is, after all, what the union agreed, and what it agreed in full knowledge of the European Agreement and the 2004 regulations. And surely they would not have agreed to arrangements which were destructive of the right to holiday pay. Plainly, the agreement at basic pay is not so destructive.
I'm sorry, I know that this has nothing to do with 221, 224, but assume that it had. I mean, 221, 224, as I understand it, if it applied here, which everybody now, of course, recognises it doesn't, would give them the greater sum.
Well, it might do so. There is still issues to be decided at the tribunal as to whether the two payments constitute remuneration.
All right, but put that aside. I mean, I think my question really is this. I mean, assume that 221 to 224 were redrafted to give, in this sort of situation, basic pay only. You would say that that is entirely consistent with Robinson Steele, would you?
Yes.
You would have to.
Certainly. And we'll see in a moment that 221 to 224 very often does have the effect of excluding payments which individuals commonly or usually earn. It's simply the product of a scheme which has to have particular rules, particular reference periods, particular averages. You need to have such a scheme in order to operate if you're going to include irregular...
And presumably British Airways thought that 221 to 224 wasn't very satisfactory for them because they fought tooth and nail to say they didn't apply.
Well, it can also be said that the union thought them unsatisfactory because, or at least the union thought them unnecessary because they didn't seek to argue that they should be incorporated by agreement. Could always have said that. If the union had thought, well, this arrangement really should reflect the statutory scheme which applies outside aviation, they could have said, well, please agree, employer, please agree, British Airways, that the provisions of section 221 to 224 will be treated as applicable. They didn't seek to say that. They were perfectly happy with basic pay. And this is simply a point that somebody in Unite has spotted for our general entertainment, but it does not reflect any sense on the ground that the pilots or the pilots' union were expecting to get anything more than basic pay. They weren't.
But I mean, this same point could arise quite outside the aviation,
Yes.
Straight under 221, 224.
Yes, outside the aviation field. And importantly, of course, it can arise for non-fishing seafarers. If they're paid basic pay and they say there's some allowance that hasn't been included, the employer, if my learned friend's right, can find themselves on the end of a criminal charge for not undertaking some principle of averaging in relation to those allowances. So that's the context in which the point could arise. We'll return to that. So we say that the consistent message of the Court of Appeal through those two cases, and I'll show you later what the Court of Appeal said in this case, that these are discretionary provisions, and it's only where the pay is set at a level which is destructive of the right that the ambit of discretion is infringed. We say that is a sound principle, entirely consistent with the Working Time Directive, a fortiori the Aviation Directive, which has built into it the extra discretions, and which is intended to give effect to an agreement. And ex hypothesum is less prescriptive in its approach. Can I then go to Robinson Steele, which follows on in a way neatly from Marshall's Clay? That's in tab 42 in volume 3. The issue, of course, in the case was not how much individuals were going to receive, but whether they were going to receive pay, extra pay in respect of holidays or not. This was not in any sense a computation case. This was an all or nothing case. Either their holiday pay had been validly rolled up into their contractual arrangements, in which case they were entitled to nothing, or it hadn't, in which case they were entitled to full holiday pay. In the event, in fact, the Court of Justice comes up with a solution which gave the employees only a Pyrrhic victory, it is generally said, because they said that although it wasn't appropriate to roll up holiday pay, if the employer could show, by reference to the contract, that there was a distinct allowance for holiday pay, and that he wasn't simply deeming after the event that his pay included holiday pay, then he could set off the holiday pay element in his normal pay, and he wouldn't have any liability. That's the bit that one gets in the very final section of the judgment from paragraphs 64 to 69. So that Robinson Steele was certainly a victory for employees whose contracts of employment didn't make clear what element was holiday pay, and whose employers had simply tried to say, well, it's deemed to include holiday pay, but it was in the result a defeat for employees whose contracts were transparent in relation to holiday pay. It's paragraph 66, simply for your note, where the court comes down with the conclusion. Article 7 of the directive does not preclude, as a rule, sums additional to remuneration payable for work done, which have been paid transparently and comprehensively as holiday pay, from being set off against payment for specific leave. But Member States are required to take the measures appropriate to ensure that practices incompatible with Article 7 are not continued. But the point of the case, as I say, was pay or no. It wasn't computation. And one sees the context a little if you go to the judgment at paragraph 55. Under Article 7.1 of the directive, the Member States are to take the measures necessary to ensure that every worker is entitled to paid annual leave of at least 4 weeks in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice. The fixing of the point at which payment for annual leave must be made comes within those conditions. So that's what the case is about. The fixing of the point at which the annual leave must be made. In that regard, the Member States must ensure that the detailed national implementing rules take account of the limits flowing from the directive itself. The directive treats entitlement to annual leave and to a payment on that account as being two aspects of a single right. The purpose of the requirement for the payment for that leave is to put the worker during such leave in a position which, as regards remuneration, comparable to periods of work. Now that has to be understood against the background that the employers were saying we're liable for nothing. Yeah, there wasn't a question of whether some particular allowance should be included or how the computation should be conducted. Employers saying, I'm entitled to pay nothing. Tribunal of the European Court says, no, you've got to put them in a position comparable to periods of work, so they've got to get their salary. Accordingly, without prejudice to more favourable provisions under Article 15 of the directive, the point at which the payment for annual leave is made must be fixed in such a way that during that leave, the worker is, as regards remuneration, put in a position comparable to periods of work. And we emphasise the word comparable there. Not saying you must receive the same as if he was at work. Must be something comparable. And the plain intention, we say, is to allow for the very kind of flexibility.
Well, anything is comparable in one sense.
Well, yes, one has to assume that the European Court had something in mind there.
Well, it surely means like. Equivalent or the same.
Well, in my submission, it's very notable that the word is not equivalent. It's comparable. It's something capable of comparison with, not the same.
What does it use in other languages, do we know?
I haven't studied the Finnish.
In order to resolve these matters, and certainly to be beyond doubt on them, we have to ask ourselves what other national courts might think and what other national...
Yes, I confess I haven't studied the Finnish or the Greek text.
I suspect it means normal pay.
Well,
it might be interesting. I mean, it's very simple. Just look up the French and the German and the Spanish.
Yes.
Which bit of the
English was
reasoning
the
of Law
language of the chaos.
Which bit of the reasoning of Law Justice laws is being rejected here?
None of it.
None of it. And so how did the Court of Appeal didn't approach it in this way then?
Well, the Court of Appeal, in our submission, approached the question of the discretion in exactly the same way. They reached a provisional conclusion, because of course they referred the question to Europe. They reached a provisional view that rolled-up holiday pay didn't infringe the European provisions, but that's a question about the application rather than about the principle. And in my submission, nothing in the Court of Appeal, either in this case or in Bamsey, is inconsistent with what the court itself has said.
Lords, with some hesitation, we have got the French text here, and again, we can make that available. But so far as it assists, in Stringer, where the ECJ is citing from Robinson Steele, they talk about la rémunération ordinaire and congé annuel payé, and then there's dans une situation comparable. So we can pass those up in due course.
Thank you very much.
Comparable, not même. It has to be remembered that English was thankfully, in Stringer, the language of the case in both Stringer and Robinson Steele, and therefore has primacy in any event.
I'm rather puzzled in the light of paragraph 66. I mean, if you say, look here, you're employed and you'll get for 11 months, £120 a month or whatever it is, £15 a month of which is your holiday pay for the 12th month when you'll be on holiday. I mean, is that permitted or is it not permitted, but it has no financial consequence because you can set it off?
The latter, as long as the provision is sufficiently clear.
It's not permitted, but
It's not permitted, but you can set it off.
But you can set it off in...
Well, can you, for the future, these paragraphs are dealing with past payments. 65 payments
Yes,
already
well,
made,
I
and
think
66.
the message is it would be an illegality, but a technical one. And there have been cases where, since in the English jurisdiction, where employers arrangements have been upheld. I suppose the importance of the case is that it does place an onus on the employer, so that the employer who says, "Oh, don't you remember I told you at an interview that you're..."
Well, I can see that wouldn't wash, but if you actually spell it out and pay it monthly,
Yeah.
The
does
last
this
paragraph,
leave it as permissible or impermissible?
69 does seem to be the future as well, doesn't it?
Yes. I think that's the position, but that, of course, was the debate. It was not a debate about allowances or irregular payments. Just before leaving the case, though, can I just go back to paragraph 60? After comparable to periods of work, comparable. Furthermore, account must be taken of the fact that under Article 7.2 of the directive, the minimum period of paid annual leave may not be replaced by an allowance in lieu, except where the employment relationship is terminated. That prohibition is intended to ensure that a worker is normally entitled to actual rest, with a view to ensuring effective protection of his health and safety. So that comes back to the point repeatedly made in the British cases, that the purpose of the payment is simply to ensure that he's able to take his rest. And that, we say, has major implications for the ambit of the discretion. A regime such as that referred to by the questions at issue may lead to situations which, without the conditions laid down in Article 7.2, the minimum period of paid leave is, in effect, replaced by an allowance in lieu. It's appropriate to add that Article 7 of the directive is not one of the provisions in which the directive expressly allows derogations. So we say that Robinson Steele is entirely consistent with our submissions in this case, and indeed reinforces them in emphasising the health and safety basis of the provision, and is certainly not seeking to be prescriptive about the mode of calculation or the allowances. Simply weren't an issue in this case. Similarly, when one moves over the tab to the next tab, 43, to the Stringer case, you, I think, appreciate what happened in Stringer. There were some civil servants who were on salary only, who had been away for a considerable period of time. There was an initial period where they got full pay, a further period where they got half pay. Then there was a period where they got what was called pension rate, an even lower rate of pay, as sick pay. And then there was a period where they got nothing. There was no question in this case about allowances. It's simply salary at a reducing level. And the question was, could they get as holiday pay their normal salary, or could they only get what they were entitled to as sick pay, which was nothing, because they had exhausted their entitlements.
Well, if it hadn't been nothing, but it had been half, what would the answer have been then?
Well, the answer in the case was that they were entitled to their sick pay, their holiday pay. So it didn't matter whether their entitlement would have been to half or to pension rate or to nothing, because it said that being sick doesn't deprive you of the right to a holiday. That's the message of the case. You can take. You may not be able to take your sick leave whilst you're absent, but you should be able to take it when you come back. And an employer shouldn't be able to say to you, well, because you were away for a long time, it's now too late to take a holiday or to be paid in lieu. So that what the court decided was that when it came to calculating the in lieu payment on the termination of employment, individuals were entitled to their normal salary, not to a reduced salary by reference to the sick pay provisions. But that was a contest. It had nothing to do with allowances or irregular payments. Paragraph 45 of the Advocate General's opinion, and goes to page 943. There is again emphasis about the discretion allowed to member states. Paragraph 45, as regards the division of legislative powers between the community and its member states in connection with the grant of the right to paid annual leave, should first be pointed out that in adopting Directive 203/88, the community legislature availed itself of a legal instrument which, under the third article of Article 249 EC, grants the national authorities a degree of discretion as regards the choice of form and methods of transposition, but at the same time imposes requirements insofar as the directive is binding as to the result to be achieved on each member state. See the leading case of Wye. Member states are obliged to choose, within the bounds of the freedom left to them by Article 249 EC, the most appropriate forms and methods to ensure that the effective functioning of the directives account being taken of their aims. And that's what one always has to go back to in the EC measure. What's it about? What's it seeking to achieve? And here, of course, it's health and safety. Consequently, with regard to the transposition of the right to paid annual leave, the national legal systems are given considerable, but not unlimited, options. Therefore, in fulfilling the obligation laid down in Article 7 to take the necessary measures, member states must always take account of the objectives of the article. But the limits are constrained by the objectives. And the court says nothing inconsistent with this. And one goes to paragraph 57 on page 983. Dealing with the payment in lieu. And the argument here, of course, was that because these individuals had been absent, in one case for 4 years, because they had been absent from work for a very substantial period of time, they had not accrued sick pay, they had not accrued holiday entitlement and were not entitled to be paid as if they had been at work. But the European Court says, no, you have a right to your holiday pay, so you are entitled to your salary, the salary that they would have had if they had been at work. No provision in Directive 2003/88 expressly lays down the way in which the allowance of the minimum...
How is that consistent with the objective of health and safety? I mean, if you're off sick and have been for years and years, and you were never going to work at all in the period, I mean, how is the result, at least in this case, consistent with the notion that you have to give them full pay?
Because the notion is that the individuals must still have the opportunity to take that holiday, even if it arises, as it were, on the termination of their employment.
Well, because of their health and safety, even though on the facts they're going to be lying sick.
Yes.
Seems very odd to me.
Well, the argument is that sickness may ultimately leave you with as much need of a holiday at the point of return as being at work may do.
How does it fit in, I wonder, in practice with the usual doctor's advice, if you've had a serious illness, that you should have a period of take it easy?
Yes.
It gives you a sick note until then, presumably.
Well, the employer might have something to say if you then went to Benidorm and had a holiday on it. The idea is that you are disabled from both work and play. At all events, that's what the European Court decided, that that being sick meant that you didn't forfeit your rights to holiday and your right to paid holiday, and that then fed into the termination payment, because you might, at the point of termination, then want to take the holiday before taking up your next job. Paragraph 58. However, according to the case law of the court, the expression paid annual leave in Article 7.1 of the directive means that for the duration of annual leave within the meaning of that directive, remuneration must be maintained, and that, in other words, workers must receive their normal remuneration for that period of rest. Now, I emphasise that what that's talking about is the individual's normal salary. There's no question there of irregular allowances being included or even being sought to be included.
So which paragraph you just read?
Paragraph 58.
Thank you.
The contrast is, well, do I get my normal salary or do I get nothing?
I mean, just assume in the case, 50% was basic, 50% was routinely earned because you're whatever it is, I don't know, flying or whatever. I mean, you would say that's fine, they can just pay the basic.
Yep.
And if it was 25%, you'd probably say the same.
Yeah, so perhaps might want to know what the total figure is. Clearly, it's elephants and postboxes, we say. You can't necessarily define them with precision, but you know it when you see it. If there's a derisory payment, something which is would in principle tend to discourage the taking of holiday, then the line is crossed. And as Lord Justice Laws stresses, it is going to be a question of fact and degree when that bottom plimsoll line.
And how do you factor in the fact that it's compulsory to take the holiday?
Well, as I say, you have to then ask the question on a more abstract basis.
You would say that's irrelevant, that is compulsory.
Yes. You have to ask the question more generally, is it set at such a leave where such a level were it not compulsory, it would be discouraged.
I mean, I suppose at some level of abstraction you could say, well, there it is, if the chap's actually used to earning twice as much, okay, he's forced to take his holiday, he will take his holiday, but actually he'll go and do some part-time work for somebody else in that month. So he won't have as good a holiday as he would have had if you had paid him the full sum.
Can't stop him from doing that.
No, exactly, but you can discourage him from doing that if you pay him more.
Well, obviously, the more you pay somebody, the more they're going to like it. Whether it discourages them from doing other work or not will perhaps depend on the individual. Mr. Short reminds me that the Employment Tribunal said in its findings that there was no evidence that the pilots were not taking the leave, either the basic leave to which they had to take, or the non-compulsory additional leave, which was paid at the same rate. That's in paragraph 37 on page 73. So that's a further indication that, from what one can see at a glance, that the level of pay here is not such as to discourage the taking of leave or to be inconsistent with the basic right. And as I say, the union was perfectly content to agree this level of pay. So for them now to be saying, well, this is somehow destructive of the right, this is inconsistent with the basic scheme is somewhat surprising. So we say that the Ainsworth which is also called Stringer Ainsworth, and Robinson's Steel case take the matter no further. They're simply not concerned with irregular allowances. I underscore again the fact that in paragraph 60, the phrase which is repeated in the core part of the decision is that the purpose of the requirement is to put the worker during such leave in a position which, as regards remuneration, is comparable to periods of work. It's not equivalent.
Paragraph 60, letter what?
It's just by letter H, just above letter H.
I see.
Last line.
Again, it's comparable, not the same or equivalent. And
They define that in 61 as meaning normal.
well, they refer to it as being normal. But in the context,
Maybe we better just send the case to Europe and ask them what they meant by normal remuneration.
well,
That's what it boils down to, I think.
I want to address.
That's what the whole
address
case
that.
boils down to, as far as I can see.
I want to address that in due course. It's obviously one matter your lordships will have to consider whether the assistance of Europe is necessary. But I would say that in this context, what one's got to remember is that the contrast is between normal salary, what they actually got and working, which didn't include any allowances, and sick pay.
Well, some might say that normal remuneration is what you normally get.
Yeah, but all I'm saying is that this was not, they did not have to address the considerations which arise in this case. It was simply a question of getting more salary.
Because their remuneration, at any rate in this case,
Yeah.
their contractual remuneration included the allowances, didn't it?
Yeah, it didn't in the Robinson Steel case.
No, but in our case it did.
So they didn't have to address that question. And when they speak of normal pay, they're simply speaking of someone's salary.
Well, they're talking about normal remuneration. I mean, maybe we'll have to ask them.
Normal remuneration meant salary in that case. It didn't mean bonuses, other payments of any
Maybe.
kind.
Because the point didn't arise.
Because the point didn't arise.
So we don't know what they meant.
So we'll have to ask them.
Well, I have something to say about that in due course, but I, of course, acknowledge that that's one of the matters that your lordships will have to consider.
But this point would apply equally, I mean, you know, to mainstream cases as to aviation cases.
Lord, yes, and Your Lordship makes, if I may say so, a very important point there. Because if Miss McNeill is right in the full range of her submissions, if she's even right in saying that against emanations of the state, Article 7 is directly effective, I'm going to come to that in due course, it follows that any state employee can say to a tribunal, well, I don't like sections 221 to 224, I don't like the way they operate in this case, I don't like the fact that they deny me overtime benefits, I don't like the fact that they deny me commission, I don't like the fact that the reference period excludes a period when I received a lot of money by way of bonus. They can simply say, no, you've got to test this according to the European concept of normal remuneration, and one will face the prospect of tribunals all over England referring entirely separate questions to the European Court as to whether, on particular facts, the test of normal remuneration is met. Now, that plainly is not intended, and it's not intended because the directive confers discretion. And as was held in BAMSI, sections 221 to 2224 are a perfectly legitimate application of discretion.
What you're saying is we must be careful how far any decision unravels section 221, even though it's not an issue.
Yes.
Is there any way of avoiding that? I mean, one can presumably, if the question of a reference arose, one could presumably and would presumably explain the position under section 221 and highlight it as a potential problem.
Yes. I do say that if one stands back from it, one can see that Europe would never have intended a detailed scheme such as that to be the subject of daily challenge. Putting it the other way around, and I want to come to this as a distinct submission, one really does have to have a scheme before one can make a judgment about normal pay. So far, we have simply spoken about whether these particular payments should be in principle included. And a question which my learned friend has not addressed is the question, how much does she say should be paid? Now, she can retreat from that question, if your lordship's put it to her, by saying, well, this isn't an issue which has arisen yet because the tribunal divided, by agreement, the issues. If you go to the main bundle, page 231, divided the issues into 1, 2 and 3. Question 1 was whether as a matter of domestic community law paid leave for the purposes of Regulation 4 is to be calculated in accordance with Regulation 16, and if not, how it's to be calculated. That was the question which they did address at the preliminary hearing, and it was agreed that the preliminary hearing would simply address that question. And then there are two further questions applying the method of calculation determined in the first issue, whether flying pay supplement and the taxable element of time away from base allowance properly form part of their remuneration. That's a question which has not yet been decided. And thirdly, applying the findings upon issues 1 and 2 above, how much, if any, is to be awarded by way of compensation. And Ms McNeill can say to you, well, we haven't yet decided even whether these payments are remuneration, let alone how the calculation should work. But it is a material question to ask, because in my submission, there is no answer that can be given.
Doesn't she have a second response too? Because she says, well, you accept that if you pay, you call it a derisory amount, somebody is then going to have to decide how much should be paid, and therefore the mere want of machinery isn't, so to speak, a decisive answer in your favour.
Well, what we would say is that if a derisory amount is paid, first of all, that's going to be a highly exceptional situation. And secondly, we suspect that the normal answer is, well, individual gets their basic pay, then that will be certainly comparable, if it is not exactly the same as or equivalent to normal pay, and that will be a proper remedy. But in my submission, it is very important to focus on this further question because it is illustrative of the difficulties in Leonard Friend's argument. How much would she say is owed by way of TAFB? What principles, or by way of flying pay, what principle is to be observed? Is one to look at some kind of median payment, an average payment? If so, over what period? Does one discount periods of illness or maternity in looking at the reference period? These are all questions which any scheme concerned with the award of pay has addressed. You find these questions addressed in sections 221 to 224. You find them in the maternity regulations. You find them in any scheme which does provide for payment during special weeks. And it may be instructive if we can actually have a little look at sections 221 to 224.
Just before we go there, don't you have the problem that, in that submission, you're really having to delete the word normal in Stringer, and I would have thought probably the word comparable, because you say that's not the test. The test is whether there is pay which can be regarded as more than derisory. So that's not a test of normality. If we were dealing with a test of normality, we would be asking ourselves, in relation to overtime, is that part of normal pay? In relation to, you mentioned commission a moment ago. I haven't quite got in mind what sort of commission you were talking about. Is that part of the normal pay? And in the present case, we'd be asking, is flying supplement, flying part of the normal pay? And one can understand that sort of question, but I think you're not asking, you're not suggesting that's the right question, really, but then you're up against the words of the Court of Justice.
Make it clear, I'd certainly say that in this pay structure, basic pay is normal pay. If you ask a pilot...
Well, it's normal, they get it, but is it their normal pay looking at their job? The answer is they would certainly say no. Normally we're flying, and normally we get...
it's not normal remuneration. I can see it might be normal pay, but it's certainly not normal remuneration, because your remuneration is the whole package.
Well, it depends and here's the rub, it depends at the period over which you're looking at it. If you ask what's your normal pay in a particular week, the answer is it depends what you're doing or you're scheduled to do in that week. And of course, nearly all the relevant provisions do...
Maybe the moral of the story is never have a preliminary issue, because whatever happens, somebody says it's a waste of time.
Well, much truth in that. But can I just take you to sections 221 to 224, just to illustrate the need for a scheme? If one goes to volume 1 of the Authorities Bundle, tab 2...
But here, there's no scheme, is there? On anybody's case, there's no scheme. On your case, there's no scheme.
Indeed. And we say that without a scheme, you can't say that basic pay fails to satisfy comparability or normality, even assuming that it needs to satisfy normality or comparability. Without a scheme, you can't say that paying a pilot's basic pay fails to meet that criterion. It's only if you have a scheme which tells you that irregular payments have to be included on some kind of median or average basis that you can say that there's actually been an infringement. Otherwise, all one says is, well, there isn't a scheme. There's no doubt that what the starting point is to say, there's no doubt here that the basic pay is not derisory. It doesn't discourage anyone from taking pay. It is perfectly naturally described as somebody's ordinary remuneration. Its proportion, even taken over a year, to total pay is so overwhelmingly the majority pay that it couldn't be said that it's what's paid by way of basic pay isn't comparable to even the best month. that Mrs. Williams will have enjoyed. So we say there are no initial reasons for regarding this as being other than normal or comparable. We'd say that if you are going to go on and say it falls short of some particular standard, you need a means of measurement. And can I just show you, because it is in my submission quite illustrative, sections 221 and following in all their glory. They are at tab 2.
I mean, were these applied in Stringer
Yes.
and found wanting?
Well, no, there was no issue of calculation in Stringer. The only question was whether the fact that they'd been away sick disqualified them altogether.
No
All or
holiday
nothing.
leave, no holiday leave at all.
Well, they had accrued leave, 4 of them, which they were claiming as an in lieu payment. But there was no question of allowances. Either their sickness disqualified them from receiving anything, or, as the European Court held, notwithstanding their sickness, they had to be paid their ordinary salary, which was a flat salary, which didn't include allowances.
No bonuses at all.
No bonuses at all. They're civil servants.
Well, lots of civil servants have bonuses. Lots of civil servants have bonuses.
Having said that, one does read that it's not unknown. They were quite junior civil servants. Just going to sections 221 and following, what you see at the outset is, first of all, a split between sections 221 to 223, employments with normal working hours, and section 224, employments with no normal working hours. So you have different regimes for those two. And within normal working hours, you have different regimes for employments where the remuneration doesn't vary according to the time of work. That's section 221.
What does normal working hours mean?
That is defined in section 234. And this is the basis of what becomes the tarmac roadstone BAMSI distinction. Normal working hours, where an employee is entitled to overtime pay when employed for more than a fixed number of hours in a week, another period there are, for the purposes of this Act, normal working hours. So that just tells you that overtime doesn't destroy normal working hours. But then subsection 2 says that the normal working hours are the fixed number of hours, and subsection 3, where the contract of employment fixes the number or the minimum number of hours in a week or other period, and that number of hours exceeds the number of hours without overtime. The normal working hours are that number or minimum number of hours, and not the minimum number of hours without overtime. And it's that conundrum which has been construed in the cases as meaning that it covers guaranteed overtime.
But this 234 is all about contracts that provide for overtime payments.
Yes.
It doesn't tell you what the answer to normal working hours is
Beyond that, it doesn't.
vast quantity of people who don't have prescribed working hours.
Yes, and if you don't have normal working hours, you're in section 224.
Yes.
But as
One is in the territory of having to work out what's normal.
Yeah, well, one's in the territory of having to work out whether there are normal working hours or not. And overtime is, in fact, the only
That's what tells you.
point at which there's been a difficulty about that. Either people do have 40-hour weeks, or they have flexible times, and that particular borderline hasn't been the subject of difficulties. But there are other difficulties which emerge. Clearly, as between sections 221 and 222, you have different regimes according to whether the remuneration varies according to the time of work. And basically, the principle is, if the remuneration doesn't vary according to the time of work, you simply look you look first under section 221 to the contract in force on the calculation date, the date when you need to compute the relevant entitlement. But if you are looking at remuneration which varies according to the time of work, and you're here thinking of people on rotating shifts who may get more money when they're on the evening shift than when they're on the day shift, there you do an averaging, and section 2222, the amount of a week's pay is the amount of remuneration for the average number of weekly normal hours at the average rate of remuneration. And for the purposes of subsection 2, subsection 3 tells us you divide by 12 the total number of the employee's working hours during the relevant period of 12 weeks, and you get the average in that way. But
Is remuneration defined?
No.
I mean, what happens if you're the doorman at the Ritz, where everything you get is tips, basically? I think you used to have to pay for the place.
Yes. If you're a normal working hours person and you have a contractual entitlement to the tips, then you probably are entitled under section 221 to the benefit of the tips. But I want to show you some tweaks on that in a moment.
So what's the purpose of this whole calculation of a week's pay?
Well, it has several purposes. Obviously, it's been incorporated in the working time regulations as the way to work out an individual's holiday pay.
Yeah.
But it also applies in computing the amount of a redundancy payment, because as you know, redundancy
Although all
payment...
that is subject to the maximum in section 227, which must make these complicated calculations unnecessary in quite a lot of cases.
It tends to be for lower paid employees that they become important, although not always, as I'll show you in a moment. But redundancy payments, unfair dismissal, statutory maternity pay, almost any occasion when the statute says entitlement is computed by reference to a week's pay, for example, failure to consult under the consultation on redundancies provisions in section 188 and following of the 1992 Act, they all say computation of entitlement in accordance with a week's pay, and it takes you back to these general provisions.
So going back to the expression average weekly remuneration, there's no definition of weekly remuneration, then is there?
No.
And does that mean, therefore, everything that you're paid in the week?
No, it doesn't.
Under your employment?
As you see, when you go to section 221, if you look at subsection 2, subject to subsection 222, if the employee's remuneration for employment in normal working hours does not vary with the amount of work done in the period of employment, the amount of a week's pay is the amount which is payable by the employer under the contract of employment in force at the calculation date if the employee works throughout his normal working week. But, subsection 3, subject to subsection 222, if the employee's remuneration for employment in normal working hours does vary with the amount of work done in the period, the amount of a week's pay is the amount of remuneration for the number of normal working hours in the week calculated at the average rate of remuneration payable by the employer, essentially over the previous 12 weeks. And that's been held not to include, for example, commission, which is payable by results. If I just show you quickly the Evans and Malley case in the Court of Appeal, which is in tab in Authorities Bundle 2 at tab 26. These were very well paid individuals, sales representatives, and Mr. Evans, the test claimant, had a basic annual salary and plus commission on contracts that he was successful in obtaining. So as with salesmen generally, it was results which determined whether you simply got the basic salary or whether you got a lot of money. And when he claimed for his holiday pay, he said, well, you should look at all the work that I brought in, all the successful results that I've had, and the commission that's generated. No, says the Court of Appeal, it's sufficient just to look at the holding. The Employment Tribunal had correctly concluded that the applicant's remuneration did not vary with the amount of work done in normal working hours, and that therefore the amount of a week's pay for the purposes of holiday entitlement under the working time regulations fell to be calculated in accordance with section 2212. In allowing the applicant's appeal against that decision, the EAT had erred in holding that section 2214, which provides that in this section references to remuneration varying with the amount of work done, includes remuneration which may include any commission or similar payment which varies in the amount, has the effect of overriding the normal meaning of section 2213. So although the applicant's commission was not payment by reference to the amount of work done, his case came within section 2213 rather than 2212. So the EAT was wrong to say that he was entitled to his commission.
But it comes in under some other provision.
Well, no, it didn't. It didn't, because had he been able to show that the amount of commission was referable to work done rather than results achieved, then he would have fallen within section 2213. And it perhaps goes to my Lord's example about the footballers yesterday. Footballers typically are on win bonuses and competition win bonuses. And so they get a huge bonus if they win the FA Cup or the European Cup or something of that kind. And they, poor things, if they went to the employment tribunal, would not, by virtue of Evans and Mallow, be able to include those payments in their holiday pay payments, because they are payments for results rather than for amount of work done. This is detail, but it is necessary detail.
So if your skill consists in doing something quickly, piecework,
You get more, but if your skill consists in persuading a customer to buy
secondary glazing, you don't.
Absolutely right, and no suggestion that that infringes.
That may be a European point, perhaps.
Well,
It didn't go there anyway.
Yeah, may I sort of provisionally agree with your lordship there that the effect of Miss McNeill's submissions is that really all these sort of issues would be up for grabs in Europe. What is necessary in order to have a workable scheme is to have a system of workable rules. And sections 221 to 4, I'm reminded, are used for maternity suspension under the ERA, but they're not used for SMP, statutory maternity pay. They're governed by the separate regulations I handed up earlier, which have a yet separate set of rules for computing reference periods, averages, and so forth. And they look, in fact, at an 8-week period. But the fact of the matter is that one does need a series of rules and principles. And it's obviously possible in these circumstances to have an averaging process, which the Act does for remuneration which varies according to the time of work, and for cases where there are no normal working hours. But even then, it's necessary to have various subsidiary provisions. For example, in section 223(2), there's specific provision that if in any of the 12 weeks immediately before the calculation date, no remuneration was payable in a week, you discount that week. So you don't simply have a reference period, but you say, well, are there reasons for discounting weeks in that period? Being away sick might be a reason why you didn't earn or didn't earn as much in that week, and therefore that gets discounted. There also, of course, in the most basic terms, needs to be a definition of week, and you won't be disappointed to see, if you go to section 235 on page 825 of the Butterworth, 3 pages over, that week is defined as being either a week ending in a Saturday or otherwise in relation to any employee whose remuneration is calculated weekly by a week ending with a day other than Saturday, a week ending with that other day in relation to any other employee, a week ending on Saturday. And the point simply is, if one is going to have a scheme, whether it's by reference to weeks or months, you have to know when it starts or finishes.
Where was that? That's Saturday.
That's section 235, definition of week, right at the bottom of 235(1). All these terms need to be defined. You need to have specific reference periods. You need to have rules about which weeks in the reference period count. You need to have rules about whether it's averages or mean. And there is simply no intrinsic answer in the
So if you have no rules, what then?
Well, then you have no answer, in my submission. You simply can't say, and it's for the claimants to prove a breach of the regulations. You can't say, let's simply assume for the moment, we're looking at a test of normality or comparability. You simply can't say that by paying or not paying a particular amount in addition to basic pay, that any principle has been infringed. You simply can't, without having a reference period, an averaging period, rules for what is to count in what circumstances. You have no yardstick.
So if you had an agreement for half basic pay for holiday, how would that be consistent with, at any rate, the language used by the European Court in these cases?
It might not be. It might not be. But that would be because one could recognise as an elephant or postbox something which plainly falls short of ordinary pay. One simply can't say that about basic pay. An individual who has already flown there 900 hours or worked there 2,000 hours in a year will definitely not be earning those benefits in a given week, whether they're at work or not. And they're simply being given a windfall if they're then given on some notional basis an amount which they couldn't have earned if they'd been at work. And ultimately, my submission, one has to stand back from it and ask the statutory question, have these pilots been paid? And even giving paid a...
Well, if you take my example of half basic pay, they would have been paid. The answer to that would be yes, they have been paid. But once you concede that half basic pay might fall foul of the expression normal remuneration, then we're back to the European Court to find out what they meant.
Well, I'm never going to be able to define to your Lordship's satisfaction the point at which the line is crossed. And Lord Justice Laws makes this point himself much better than I've just done in the Marshall's Clay case. But what one can say without whatever else is right or wrong in my submission is that the collectively agreed rate, the rate which the unions agreed in full knowledge of the European Agreement, the directive and the regulations in 2005, is not a rate which is destructive of the right to pay. It's
well, then curiously, the directive doesn't say whatever is agreed collectively.
No, but plainly it's an environment in which collective agreement is treated seriously because the reference is made back to national law or practice, and it's referenced from a European collective agreement.
But did you get that reference to national, whatever it is, even in the non-aviation, even in the routine cases?
Yes.
And that's what takes you to... I mean, this is a one-point case. It's a very tricky, interesting point, but it's a one-point case. I mean, you're going to get, basically, aren't you, the same answer within 221 to 224 as you're going to get outside it. In other words, if in a case like ours, they said, right, basic pay X, and then you have all these supplements on top, or assume they had as much again on supplements, you would, whatever the contract said, you're forced into 221, 224, and then you'd have to ask Strasbourg, well, not Strasbourg, Luxembourg, what's the answer to that?
In my submission, there will simply be endless argument if there is a free-floating concept of normality, because individuals, and the example is already there in the Evans and Malley case, individuals will say, well, I'm not being paid sufficient because my commission's not taken into account. Or an individual who earns a big bonus in February, takes his holiday in August, may say, well, the bonus is most of my pay. I don't see why a 12-week reference period should exclude my entitlement to have my bonus taken into account in the context of holiday. And one can think of many other examples. In a sense, the rules are necessarily arbitrary because they have to draw lines in the sand at some stage. But to say that they are open to being challenged as being inconsistent with a European concept of normality would result not only in the tribunals being flooded, but the European Court of Justice being flooded. And one goes back to it, was that intended? Answer, no, because the Working Time Directive, a fortiori, the Civil Aviation Working Time Directive, conferred discretion on member states. And acknowledging the force of your Lordship's point that it's always difficult to see at what point the minimum threshold is crossed, one can say with real confidence in this case, the payment of basic pay to these particular individuals in accordance with a collective agreement does not cross that threshold. And that is, in a way, the simplest and
Cross the threshold of what?
The threshold of being destructive of the right to pay.
I mean, that's my difficulty, that you move between two concepts. 1 minute you accept that normalcy is the test and assert that basic pay is normal, and the next moment you say actually the test is whether there is really no pay, no paid annual leave at all, destructive. That's the law's test, and that's where I have the difficulty. I mean, if normalcy is the test, I'm not sure I'm convinced that your fears about Section 221 are justified. I can see that there might be an argument in relation to commission, for example. That commission case
Over time.
Is, but in general, surely the court would be likely to say that national legislators were entitled to establish reasonable tests to ascertain normal pay.
Yeah.
And Section 221 is probably a pretty good stab.
And so here in our submission, it can't be a criticism of the working time regulations that they have simply incorporated the concept of payment, the fact that they have not.
No, I mean, it just leaves us with a problem that there hasn't been a specific test, and we have presumably, therefore, if normalcy is the test, to grapple with the question whether the present basic pay is alone the normal pay.
Yes, in my submission, the key word which is repeated in all the central sections of the judgment is comparability rather than normalcy. Yes. And I do say that comparability is something very different from equivalence. But just to meet your Lordship's earlier point, if it's normalcy with a discretion. It's not normalcy in the sense that it's open, we say, to any court or tribunal, simply to say, well, I don't think that's normal. See, how is it going to work in practice? Is it really going to be said that employers who have to compute these entitlements day in, day out, people in payroll departments, so they say, well, it's no good for in civil aviation, it's no good looking at any particular rules. You've just got to make a judgment as to what reference period you're looking at, what kind of averaging you're going to do, what kind of median you're going to
But
take.
that's only in cases where there are no detailed regulations. Here, there are detailed regulations for many classes of case. Here, the United Kingdom decided not to have detailed regulations. It just stuck to the meaning of the same language as in the directive.
That payroll officers in aviation companies.
Well,
would,
if the United Kingdom
making...
had wanted to have detailed regulations, it would have done, but it chose not to. And if it had wanted to say whatever's agreed in a collective agreement, that'll be the position, it could have done so, but it didn't. It simply used exactly the same phrase as in the directive.
It uses the expression paid, and it cannot have been intended, we say, to first of all require payroll officers in aviation companies, or for that matter, shipping companies, to make judgments week to week as to what reference periods, what payments should be included, what averages should be taken, what weeks should be discounted. And still less could it be required of tribunals to invent their own schemes on each occasion when the matter comes before them. How is a tribunal?
Do you have any theory to put before us? And forgive me if you've put it already, but if you have, I've forgotten it, as to why our government should have chosen in the general run of cases to transpose the directive in a form which very precisely quantifies, or at least enables it to be very precisely quantified, but in 2 cases leaving it right in the air.
The only explanation one can offer is the fact that there was European collective agreement in relation to those 2 cases, and the assumption must be, as the Court of Appeal said, that Parliament recognised in unionised industries, heavily unionised industries, that collective agreement was likely to provide sufficient protection. Hence, no need to provide a specific remedy in relation to pay. Hence, no need to provide specific provision in relation to pay.
But they also didn't say, and the pay will be determined in accordance with the relevant collective agreement, which they, as my Lord points out.
They didn't. The onus must be, as Lord Justice Ryman put it, the onus must be on the claimants to show a breach of the obligation. And can they really say either that they weren't paid holiday in this case, or looking at it in a purposive European way, that what they've been paid is of such a level as to be derisory or destructive of the right? In our submission, they can't.
Let's focus on what the European Court said was the meaning of the phrase we're trying to construe.
Well, yes, it's perhaps relevant to point out, of course, that Article 3 of the Aviation Directive, I think tab 17, specifically envisages that member states may bring into force the relevant provisions.
Shall ring.
Yep. Shall bring into force yes, I was going to paraphrase it, but I'll read it. Shall bring into force the laws, regulations and administrative provisions necessary to comply with this directive, not later than 1st December 2003, or shall ensure that by that date at the latest, management and labour have introduced the necessary measures by agreement. So that was envisaged as being possible that management and labour would deal with the matter. So it's not, as in other fields, where it is assumed that parliamentary norms are necessary. This was an area where collective agreement was expected to hold sway.
Can I just ask a question which doesn't directly relate to this? Maybe you can just help me. You gave us a helpful scheme indicating how the bits which weren't originally covered by the Working Time Directive were filled in. And I've got the picture as regards civil aviation, and I've also got it as regards seafarers. The other 2 categories of fishermen and inland waterways people, we've got the domestic regulations. Was there some directive in relation to each of them which required the gap to be filled?
In their case, I think it's the consequence of the general amendment.
The amending one
Required it, yes.
dropped the exclusion.
Drop the exclusion.
Thank you, yes.
As a result of which,
Yeah, so it's the consolidated one,
yes,
or is it
although the
What's the
regulations
amendment one?
maintained an exclusion, they did so more or less in tandem with separate regulations being introduced to confer
So it's the
parallel
2000
rights on
directive.
fishermen and the,
Yes.
and the waterways people.
Yes, so that's helpful.
That's,
Thank you.
if you remember, that's in regulation 18 of the amended working time regulations. One,
Yeah.
it preserves an exception, but then almost simultaneously one has separate regulations too.
Yeah.
If I can take you back to what the Court of Appeal said about all this. One goes to the main appendix at paragraph 57 on page 927.
Incidentally, the Working Time Directive itself also contemplates that the thing may be done by collective agreement.
Yes.
So it's not special to the Aviation Directive.
No, although plainly since the Aviation Directive takes
I
as its
understand
content.
what you say about that,
Yeah.
but I don't think you can make any point on Article 3 of the Aviation Directive, because Article 18 of the Working Time Directive says the same.
Yes. It is notable, though, that in industry generally, Parliament has chosen to act, whereas, I'm stating the obvious, in relation to seafarers and aviation, the aviation industries, it hasn't. And we say the reason must be because it is expected that the collective parties will sort the matter, as indeed they have.
Well, and you told us, I think, that the 2005 agreement was simply the latest version of something that had been in place before. That's
Yeah,
right.
so there have been annual, and there have been since, memoranda of understanding. But as is an accepted fact in those claimants are only entitled to basic pay under that provision, and that's what they negotiated. And indeed, if there were a
No, but the
entitlement,
point that I was looking at was that when our government was considering what to do about giving effect to the aviation directive, it would have known
Yes.
that there would have been something in place.
Indeed.
Just following up my latest point, I think it's Article 18.
It's Article 18, yes.
But this seems to deal with derogations.
Yes, maybe.
Does that help?
Are we on Article 18 of
Final
the...
provisions. I'm looking at the original Working Time Directive.
The original one, yes, sorry, the final one.
Final provisions. Member States shall adopt the laws, regulations, administrative provisions, blah, 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 by 23rd November 1996, or shall ensure by that date that the two sides of industry establish the necessary measures by agreement. It's the same provision, basically, as in Article 3.
Can I just take you to the Court of Appeal, paragraph 57.
Para 57.
Paragraph 57 on page 25 of our appendix. Well, I agree with Mrs. Judgment of the Court of Appeal. Well, I agree with Mr. McNeill that the decisions of the Court of Justice in the Robinson, Steele and Stringer cases show that paid annual leave in Article 7.1 of the Working Time Directive, Article 3 of the Aviation Agreement, requires pay which is normal pay or which is comparable to pay earned during periods of work. I do not agree with the conclusion that Mr. McNeill seeks to draw from this. In particular, I do not accept the Court of Justice decisions relevantly inform the interpretation of Regulation 4 in a way that's sufficient for the pilot's purposes. The problem with Mr. McNeill's contra-argument is this. First, neither Article 7.1 nor Clause 3 is directly effective. Secondly, in saying what it did in the two decisions about the level of holiday pay, the Court was doing no more than stating a broad general principle. It was not attempting to explain how the principle is intended to work in practice through the community. That would have been to usurp the independent right of each member state so as to decide the adoption of its own national legislation and or practice. In making such decisions, the member states must have regard to the principles of normality or comparability espoused by the Court of Justice. But there's no one way to implement them, and the member states enjoy a margin of appreciation as to how they do so. This is what Lord Justice Auld explained in his judgment in Bamsey. Mr. McNeill suggested that the decision in Bamsey may have to be reconsidered in the light of the decisions in Robinson, Steele and Stringer. I do not understand why. The Bamsey case reflected an orthodox interpretation of Article 7.1 of the Working Time Directive, and nothing in the two Court of Appeal cases undermines it. If, therefore, Regulation 4 is to be interpreted in the light of the guidance of paid annual leave provided in the Robinson, Steele and Stringer cases, it must be so interpreted in line with the full sense of that guidance. Spelling it out, the Court was saying no more than paid annual leave means pay calculated at the level of normal pay, or at a level comparable to normal pay, with the precise calculation applicable in any case being exclusively a matter for the determination of the individual member states by national legislation and or practice. If one so interprets paid annual leave in Regulation 4, the pilot's case collapses, because no national legislation or practice has determined the level of their holiday pay. There's no logical basis on which the pilots can demonstrate a breach of the statutory obligation imposed by Regulation 4.
That amounts to saying, does it, that we're in breach of European law as a country. Too bad. It's the legislator's fault. It hasn't legislated, and the courts can't do anything about it.
Making 2 points in the judgment. First, there's no reason to interpret the word paid in such a way that payment of the basic pay in this case infringes.
Yes, right. That's the first point.
The first point, but he's also saying independently, and I'm going to come to this in a moment, because we respectfully adopt it. If there's an inconsistency, the court can't write in a scheme to supply the void. And the point's made perhaps more fully. Can I just, perhaps it's convenient to turn to it.
Well, that's just simply saying that the MAR leasing approach is impossible here.
Yes, and
But despite the fact that the domestic legislation reflects the European, it's impossible to apply the meaning of the European domestically.
it's impossible because you must have a scheme in order to decide whether some TFAB earned by Miss Williams in March does or does not fall to be taken into account in July, September or November. There is no way of answering that question without having a scheme.
Well, you jolly well get an answer in Europe. If as a result of this, the pilots all went off to the Court of Justice and claimed against the United Kingdom for failing to implement the directive, wouldn't that be a possible claim?
You Court of Justice, call me Nostradamus,
Well, have to
would
go
say there's nothing to do with us, it's a matter for member states.
Yes, but what we have is a regulation that says paid annual leave. This has got to be interpreted. There is no scheme. It's got to be interpreted and applied.
Yes.
The gap has to be filled somehow or other. One obviously looks to...
One starts with what the word means. One then says, applying that to the present facts, have the pilots been paid? Yes. What limits does Europe impose, does European interpretation impose on that conclusion? Is it outside the margin of discretion for the United Kingdom to treat basic pay as
my point is, that's not what the regulation says.
No.
The regulation says paid annual leave.
Yes.
It's then necessary for those applying the regulation to work out what that means.
Yes.
And to operate it. You are assuming that without a complicated scheme along the lines of 221 to 224, it's got to mean just basic salary. It doesn't follow.
Well,
You've made an assumption which isn't
I pose this question.
justified.
What is Miss Williams entitled to if she takes holiday on the 1st of November? It's not a question that can be answered. You can start by saying, I think she should get what's normal. But that doesn't take you anywhere, because the payment in question is irregular. It's received some weeks, it's not received others, it's big in some months, it's low in others. You can't get an answer from that. And it's because you can't get an answer that the Court of Appeal says in our respectful submission rightly that if that there would be a void. If we're wrong in saying basic pay is not self-evidently sufficient, and that is our first position, if we're wrong about saying that, then there needs to be a scheme. And the Court of Appeal deals with this at paragraph 63. Ms McNeil's last proposition was that if she was wrong on sections 221 to 224, because of course the original case, as you'll appreciate, for the pilots was to seek to rely on sections 221 to 224 as applicable to these cases, which involved a rather adventurous interpretation of the word not, and has now been abandoned. If she was wrong on sections 221 to 224, then it must be for the Employment Tribunal to fashion a mechanism for determining the level of the pilot's pay by reference to the community-wide principle of normality and comparability. I respectfully regard this as mistaken as well. The pilots cannot succeed in their claims unless they can point to some national law and or practice providing for the claimed level of their holiday pay, which is the extent of their entitlement under community law. For reasons given, they cannot. Their arguments having in these respects failed, there's no residual jurisprudential basis upon which an employment tribunal can set about determining that they've been entitled to holiday pay at a level exceeding that provided in their service agreements. It's no part of an employment tribunal's function to fill any gap in domestic implementation of the Aviation Agreement and the Aviation Directive. In my judgment, it follows that the pilots are unable to prove that there's been a breach of Regulation 4. I also agree with Mr. James that consistently with this conclusion, Regulation 18 is anyway inapt to cater for a claim that the pilot has not been paid as much holiday pay as he claims he should have been. Plainly not drafted with the thought that the aviation regulations could give rise to such claims. I'm not suggesting that were BA to underpay its pilots their contractual holiday pay, they would have no remedy. And then he goes on to say that the statutory obligation under Regulation 4 is to provide paid annual leave, and he says that could be infringed by token payment. And 66, I further add this, on the basis, as I've held, that subject to the qualification just mentioned, Regulation 4 of the aviation regulations imposes no measurable level of holiday pay, but tacitly leaves it to employer and employee to agree such level. It can be said that the United Kingdom's method of implementation of the aviation agreement and directive by the aviation regulations left a partial void in what was required of it under community law. Sir James did not submit that there is, although he accepted that there might be. His primary case was that it was legitimate for the domestic implementation of the aviation agreement and directive to proceed on the assumption that matters such as the level of holiday pay were or would be subject to collective agreements. But if there is a void, the pilot's claims simply disappear into it. Mr McNeill did not suggest that there is a void. That's not surprising, since it would have meant the end of the pilot's case. In any event, perhaps their only alternative might be a claim against the United Kingdom for breach of its obligation properly to implement the aviation agreement and directive.
Well, that's the point I was putting to you. I mean, you say these problems are completely insuperable. We can't give the pilots a remedy. But if that's right, then the pilots simply need to commence proceedings against the United Kingdom before the domestic courts, and we have to find a remedy.
Yes.
So, I mean, we have to do the same exercise in a different context.
Yes, my clients wouldn't be paying.
No, but I mean, the fundamental point arises that at a certain stage, someone, if the test is normalcy, has to decide whether it's complied with, and if it hasn't been complied with, they have to award damages on that basis.
If I'm wrong in saying that basic pay in this case plainly meets any standard of normalcy or comparability, yes. I just say the primary...
And the point doesn't arise. Then
the point doesn't arise. But if it doesn't, you have no way of being able to say what the right level of payment is.
Well, surely, why isn't the Employment Tribunal the body to decide that? I must decide questions like this all the time.
No.
The EAT didn't find it difficult.
Well,
you have to do a broad averaging of some sort, of course.
But over what period?
Courts regularly say that at the end of the day you deal with this sort of matter.
We're dealing here with whether a particular payment is lawful or not. It's impossible to say in my submission to an industry, well, we'll decide later whether you have paid an appropriate amount. It must be something that is ascertainable at the point when the payroll officer goes to make the assessment. And as for tribunals, in my submission, well, we could have one tribunal saying we think we'll look at a 3-year period, another tribunal saying we'll look at a 12-week period, some tribunals saying
this strikes me as a counsel of despair.
Well, in my submission, tribunals have never, ever been asked to do anything like this. And the reason why sections 221 and 224 are there, and why the completely different set of rules under the SMP regulations are there, is that one simply can't say with irregular payments to what extent they should contribute to pay or not. There's no right answer to this. And because there's no right answer, there has to be a scheme. And it cannot be that the length of the tribunal's foot determines not only how much is to be paid, but what principles are to be applied, what period, what median, what averaging. That simply can't work. It falls into the category, we say, of having to write in a scheme rather than a word. And can I just briefly go to the Galian case, which Ms McNeill referred to in this context. It was handed up, I think, as a separate document. The facts are familiar to you, but the language of their lordships indicates that if what's been required to write in is a new and different scheme or an amendment of the statute calling for legislative deliberation, then it's not susceptible of interpretation on a MAR leasing or European human rights section 3 basis. One goes first to Lord Nichols at paragraph 33. This is, Parliament, however, cannot have intended that in the discharge of this extended interpretive function, the court should adopt a meaning inconsistent with a fundamental feature of the legislation. That would cross the constitutional boundary Section 3 seeks to demarcate and preserve. Parliament has retained the right to enact legislation in terms which are not convention compliant. The meaning imported by application of Section 3 must be compatible with the underlying thrust of the legislation being construed. Words implied must, in the phrase of my noble and learned friend Lord Roger of Earlsferry, go with the grain of the legislation. Nor can Parliament have intended that Section 3 should require the courts to make decisions for which they are not equipped. There may be several ways of making a provision convention compliant, and the choice may involve issues calling for legislative deliberation. And we say that's true here. Necessary to have legislative deliberation about how this process is to be undertaken in relation to variable payments, payments which are not payable every week and which indeed sometimes may be intrinsically incapable of falling due. Paragraph 49 in the judgment of speech of Lord Steyne. Four lines down, if the core remedial purpose of Section 3.1 is not to be undermined, a broader approach is required. That is, of course, not to gainsay the obvious proposition that inherent in the use of the words possible in Section 3.1 is the idea that there is a Rubicon which the courts may not cross. If it is not possible within the meaning of Section 3 to read or give effect to legislation in a way which is compatible with Convention rights, the only alternative is to exercise, where appropriate, the power to make a declaration of incompatibility. Usually such cases should not be too difficult to identify. An obvious example is Anderson. The House held that the Home Secretary was not competent under Article 6 of the Convention to decide on the tariff to be served by mandatory life sentence prisoners. The House found a Section 3.1 interpretation not possible and made a declaration under Section 4. Interpretation could not provide a substitute scheme, and we underlined that. It would have to be a substitute scheme. And then paragraph 63, we've got Lord Millett. He was dissenting in the result, of course.
Well, that's because he thought you couldn't interpret the words
exactly
as husband and wife to apply to people of the same sex.
Indeed, but paragraphs 63 to 65, really, for your note, he makes very similar observations to the ones I've just cited from Lord Steyne. In particular, at paragraph 65, he also picks on Anderson, says it would have been necessary to repeal the statutory scheme and substitute another. It's obviously impossible without legislation. And we make the same point
So what
here.
is your submission, Mr. Jeans, as to what paid annual leave means? You're, I think, putting it two ways. One is it means any pay short of derisory.
Yes, beyond derisory.
Sorry, beyond derisory, yes. Depends which way depends which angle you're coming at it from. The other is normal will do, and normal means basic. Which of those two are you nailing your colours to?
I'll have them in the alternative, please.
But that's basically what you're saying it means. Because we're not having to write a scheme. We know what the statute says. We just have to interpret what it means.
I mean, why can't you say it's the amount that the unions and the management agree, unless, by any chance, that is so outrageous as to offend the European jurisprudence on the point?
Do say that. Puts it rather more attractively.
But they haven't agreed anything.
Oh, they have agreed.
Yeah,
to
but
basic
contractually
pay.
agreed.
They've got a contractual agreement on it.
Yeah, that is the contractual agreement.
Or you could say that it could mean, supposing normalcy is the test, several different answers. You could have several different answers to the question, what is normal? And so long as the basic pay is within the range of possible answers, then that's enough.
Yes, I'll have that as well.
Yes.
It's against you, I think, as it isn't within the range of possible answers.
Yes.
Well, it really is extraordinary to say that what the union has willingly agreed, which amounts to £2,000 a week, it's not, one's got to look at this in real terms as well as in abstract terms, and which does represent what she will receive in many weeks, only 15 days a month that she flies, that is not comparable to.
I mean, presumably, in the normal run of things, not aviation, etc., you also get union agreements, but they are subject to 221 to 224.
Yes, that is right.
So I mean, in those cases, what the unions have agreed couldn't matter less.
No, because Parliament has written
Exactly,
in specific norms.
Exactly. And then the question is 221, 224, unless again that is something which the Luxembourg jurisprudence won't wear.
Yeah. Right, I adopt all that.
I mean, the difficulty, there is a point of principle as to what they're wearing, because they start off in clothes which refer to health and safety, and although, as my lady points out, you can actually interpret health and safety perhaps as having some relevance, even to the difference between 90% and 100%. If someone's a really greedy individual and keeps on thinking of what he was earning when he was working, he might be tempted to part-time work, but leave that aside. If it really meant something, that's one test. But if normalcy comes in, subject to your points about what comparability means, and if then that's another test. And they haven't had a case where it's actually part of the ratio of the case, but they do tend in Luxembourg to hang on to words once they've used them.
Well, they've always got to be understood in context. I think Mr. Justice Underhill recently said that even judgments of the European Court mustn't be treated as sacred texts. And the factual context in both cases was
Quite different.
Different. Do you get your normal salary for a particular week, or do you get nothing, or do you get sick pay? So there's no case where variable allowances have been under consideration. And simply as a matter, in my submission, it's quite important to go back to basics. If one asked a pilot, do you get your normal pay? Do you get your comparable pay when you're
Get your normal remuneration.
In my submission, it would be an extremely technically minded individual who answered anything other than yes. Of course, I get my pay. All that we're talking about is what in individual terms is smaller, of course, multiplied across all the pilots is highly expensive, but in individual terms is a small sum, which is irregular, isn't due every week, and you need a statutory scheme if that's going to work.
Would you be arguing, if you were in the Court of Justice, that the words normalcy and comparability didn't have a role, or at least didn't have any very significant role, bearing in mind the only basis on which this directive was held to be intra vares?
Not sure I've understood you.
Would you be arguing, in other words, that the more recent cases where these dicta appear really aren't consistent with the basis on which Article 7, providing for annual paid leave, was held to be within the powers of the European legislator?
I'd certainly want to go back to the varies, but of course one does have to remember that language used by the court is goes through many languages, and the dominant message in the European cases is that you look at purpose over language, and the purpose here is to protect health and safety, and one cannot say that paying at this level has any implications, actual or potential, for health and safety.
I mean, if Mr. Deans, the unions and management had agreed that it would be basic plus, I don't know, half the average supplements, I mean, you would say, well, that's normal too. I mean, it's all normal, it's all comparable, is your argument.
Yes,
But that's what they've agreed, and
yes.
who's to say? Certainly, you say, well, that's there's nothing very odd or erratic or about that. It doesn't breach this line of Luxembourg authority, which actually isn't concerned with that aspect at all.
Exactly. And I adopt very much what Lord Clark put to me a moment ago, that one has the very language makes it clear that there is a huge margin of appreciation, discretion, and unless one can say that what has been done in this particular case plainly infringes any reasonable interpretation of.
Was the MOA in the same terms before the directive of 2000?
I believe it was. Yes, I believe it was. Indication. I mean, clearly there have been various amendments to it, but I don't think there have been significant amendments to this part of the provision.
So I don't know whether this is relevant or not, but there's no evidence that the parties directed themselves in deciding what to agree by reference to the directive.
No, of course, had the union considered that the directive gave them something that they weren't previously entitled to, no doubt they would have not agreed what they did agree. And so they thought it was compliant. They thought it was compliant.
Well, that's a different question.
It's a different question. But
That depends whether they ask themselves whether it was
They plainly haven't agreed to that which they consider to be destructive of their rights. One is talking about one's plainly talking about a particularly protected group of workers, and that's what Parliament recognises in the limited format in which it passes the legislation. Leonard Friend referred to the ILO convention. In our submission, that doesn't take matters very far. Plainly, it's referred to by the European Court of Justice, although the United Kingdom is not itself party to it. But what one sees if one goes to the final tab in Authorities Volume 1, Article 7.1, what one sees is that the calculation, even on this abstract principle, the calculation is to be in a manner determined by the competent authority or through the appropriate machinery in each country. It's certainly never considered that there should be some international standard of normalcy of pay, and there's no attempt to address, nor should there be, the question of payments which are variable from month to month are not payable in other months. And of course, one notes, if one goes to 7.2, the amounts in pursuance of this article should be paid to the person concerned in advance of the holiday. The European jurisprudence does not require that. So it's plain that the ILO's requirements go beyond anything which the European legislation requires. Leonard Friend referred to direct effect. In our submission, this is not a matter which your lordships need to decide for the purposes of this case. Of course, it's plainly common ground that British Airways is not an emanation of the state, so that even if the directive or aspects of it were potentially directly effective, they couldn't have any effect against British Airways. I should, however, draw your lordship's attention, in case your lordships are interested in this aspect, to the decision in the Gibson case, tab 27 in volume 2. This is a decision of the Court of Appeal in terms that the working time directive is not directly effective. In general, and you can see the holding, it's perhaps not necessary to take you through the full detail of Lord Justice Mummery's judgment, held allowing the appeal that notwithstanding that Article 7 of the Working Time Directive provided the length of the minimum period of paid leave was 4 weeks, an examination of the wider context of the nature, working and general scheme of the directive in respect to the direct organisation of working time, the article left unanswered key questions affecting individual entitlement to annual leave. The concept of working time in Article 2 was not defined precisely enough to enable the court to determine the period an employee had to have worked before he was entitled to the specified period of annual leave, but in the absence of sufficient precision in Article 7 or by a reference to other provisions in the directive, it is impermissible to interpret the article as having direct effect by reference to national practice or custom of the workplace, and that accordingly provisions of Article 7 of the directive did not have direct effect so as to be enforceable. And it's certainly my understanding that this was common ground below. Certainly the Court of Appeal was of that view, and specifically so held. If we go to paragraph 56 on page 25, halfway down the paragraph, Mrs McNeill, in agreement with Mr Jeans, disclaimed any suggestion that Article 7 or its equivalent in the aviation agreement and or directive is directly effective. And in the Employment Appeal Tribunal, turning on to that judgment, at paragraph 32 on page 54, at letter E, Mr Justice Keith giving the judgment.
So where are we now?
Page 54 of the appendix in the Employment Appeal Tribunal decision, at paragraph 32.
Yeah.
Letter E. That's not because Article 7 is directly enforceable in the courts of the tribunals of the United Kingdom. It plainly is not. C. Gibson. And again, I understood that that was common ground. Plainly, as my Lord Mance points out, in the Bectu case, the court was concerned with a challenge directly to the government, which had introduced an exclusion which was completely contrary to the directive, and it was perfectly possible in that connection for the court to say that exclusion is incompatible with the directive. It's simply not there. But that doesn't advance the general question. And as your lordships know from the Frankovic case itself, it's perfectly possible for certain provisions in a directive to produce direct effects and others not. Certainly there's never been any decision that the material provisions of this directive, in particular as to the meaning of pay, have direct effect. But we would underscore the seriousness of the consequences if it were held that the provision had direct effect, because coupled with open season on normalcy and comparability, it would mean that sections 221 to 224 could be challenged in any case where the employer was an emanation of the state. And certainly any individual who wasn't happy with the reference period, the amounts that had been included, the nature of the payments which had been included, could seek to make an appeal to that wholly undefined concept. We would stress that. So we say that as they stand, the regulations do not give rise to a right of payment in a particular sum in respect of allowances. They simply don't deal with allowances, they leave it to member states. And we say that that right cannot be inserted into the regulations by interpretation. And we say it's simply not possible to move from the general words of the agreement, or the directive, to Stringer, to a finding that a particular sum in respect of TFAB or flying payment was payable in respect of a particular week of holiday. And I do say to your lordships The question must be answered. In my submission, it's not enough to say that some tribunal in the future can be asked to answer it. The question must be answered. What is Miss Williams entitled to if she is right in these proceedings? And in my submission, that is a question which simply can't be answered without a scheme and without regulations. Lords and lady, that is probably almost everything I need to say to your lordships and ladyship. In view of the time, I would perhaps just appreciate the lunch hour to consult with those instructed me before I formally sit down, but I wouldn't anticipate being more than a few minutes.
Yes, well, from comparing what you've been saying with your written case, I think we perceived that you were moving towards the end of your submissions, but we will treat you, Mr. Jeans, as not having sat down, although that isn't an invitation or encouragement to address this at great length at 2 o'clock, but we'll continue at 2 o'clock.
I realise I've delighted your lordships and your ladyship long enough.
Right.